പക്ഷെ എല്ലാവരും ഇതിനകത്ത് വരുന്നില്ല. എന്ത് പറ്റി?
അത് വരില്ല, അത് കുഴപ്പമില്ല, എല്ലാവരും ഉണ്ട്.
ആണോ? അങ്ങനെയാണോ വെച്ചിട്ടുള്ളത്?
എല്ലാവർക്കും കാണാം.
അങ്ങനെയാണ് 7-8 വരുള്ളൂ.
ഓക്കെ ഓക്കെ ഓക്കെ. അല്ല, ഈ നമ്മുടെ സ്പീക്കറെ കാണുമല്ലോ അവർക്ക്.
കാണാമോ?
കാണാം.
ഓക്കെ ഓക്കെ.
And good evening, everybody. We will have to start the webinar on criminal law reforms today. The meeting of this webinar will be moderated by Dinesh Matthew Murukan, criminal law of High Court of Kerala. And today we have a good eminent lawyer from Karnadaka, Balan. He will be delivering a
problem. Hello. Hello. Hello.
കേൾക്കുന്നുണ്ട്.
Hello. Hello.
ഹലോ.
TP unmute ചെയ്യോ? TP unmute ചെയ്യോ? ഓക്കെ, പറഞ്ഞോ. ഹലോ,
കേൾക്കുന്നുണ്ടോ? ദിനേശ് കേൾക്കുന്നുണ്ടോ?
പറഞ്ഞോ.
ദിനേശ്, ഞാൻ പറഞ്ഞ കേട്ടില്ല.
TP പറഞ്ഞോ? കഴിഞ്ഞോ?
ഞാൻ പറഞ്ഞു കേട്ടില്ല.
കേട്ടു. ഇടയ്ക്ക് വെച്ച് പോയി, കുഴപ്പമില്ല.
കട്ടായി പോയി. ദിനേശ്, പ്ലീസ് invite P Rajeev to webinar.
Okay. The warm welcome, All India Lawyers Union Ernakulam District Committee, as part of their webinar series of webinars, is conducting first webinar, that is by Advocate S. Balan, criminal lawyer from Karnadaka, and he is an exponent in criminal law reforms. And today we have along with us renowned parliamentarian and chief editor of Deshabhimani, Advocate P Rajeev, to inaugurate this function. So I welcome Advocate P Rajeev to inaugurate this webinar.
Moderator Advocate Dinesh Murukan, panelist S. Balan, Advocate Pramod, പ്രിയപ്പെട്ടവരെ, വളരെ പ്രസക്തമായ വിഷയത്തെ അധികരിച്ചുകൊണ്ടാണ് ഇന്ന് AILU ഡിസ്ട്രിക്ട് കമ്മിറ്റി ഒരു വെബിനാർ സംഘടിപ്പിച്ചിട്ടുള്ളത്. അത് സംബന്ധിച്ച് വളരെ ആധികാരികമായി സംസാരിക്കാൻ കഴിയാവുന്ന പാനലിസ്റ്റുകൾ ക്രിമിനൽ ലോ റിഫോം സംബന്ധിച്ചും അതിൻ്റെ ഇന്നത്തെ കോണ്ടെക്സ്റ്റും വളരെ വിശദമായി സംസാരിക്കാവുന്ന പാനലിസ്റ്റുകളാണ് നമ്മുടെ കൂടെ ഉള്ളത്. ഞാനാണെങ്കിൽ ക്രിമിനൽ ലോ അത്ര വലിയ പിടുത്തമുള്ള ആളല്ല. കോൺസ്റ്റിറ്റ്യൂഷൻ ലോ ആണെങ്കിൽ കുറച്ച് കാര്യമായിട്ട് നോക്കാമായിരുന്നു. എനിവേ, യു ഹാവ് എ വെരി എക്സ്പീരിയൻസ്ഡ് ക്രിമിനൽ ലോയർ, Advocate Balan, with us, I think, and also Advocate Pramod, your State General Secretary, is with us. Both of them will go into depth of this subject from different angles. എൻ്റെ ഉത്കണ്ഠ എന്താന്ന് വെച്ചാൽ, ഇതെങ്ങനെ, ഏത് കോണ്ടെക്സ്റ്റിലാണ് ഈ കമ്മിറ്റി രൂപീകരിച്ചിട്ടുള്ളത്, അതിൻ്റെ ഒരു ഡെമോക്രാറ്റിക് സിസ്റ്റം നിലനിൽക്കുന്ന രാജ്യത്തിനകത്ത് ഇത്തരം ഒരു കമ്മിറ്റിയുടെ പരിമിതികൾ എന്തൊക്കെയാണ്? ഇതൊരു പ്രത്യേക ജങ്ചറിലാണ് ഈ റിഫോംസ് കമ്മിറ്റി വരുന്നത്. കോൺസ്റ്റിറ്റ്യൂഷണൽ അമെൻമെന്റ്, കാശ്മീരിന്റെ പ്രത്യേക പദവി ഇല്ലാതാക്കുന്നത്, thereafter CAA, ശ്രീരാമ ക്ഷേത്ര അതിന്റെ ഭൂമി പൂജ. Now they are planning to move the uniform civil code on the next anniversary of Rama Kshetra, inauguration of the construction of Rama Kshetra. അപ്പോൾ ആ ഒരു കോണ്ടെക്സ്റ്റിലാണ് ഈ ക്രിമിനൽ ലോയുടെ റിഫോംസിന്റെ ഒരു കമ്മിറ്റി രൂപീകരണത്തെ നമ്മൾ കാണേണ്ടത്. 2000 അടൽ ബിഹാരി വാജ്പേയി ഇന്ത്യൻ പ്രധാനമന്ത്രി ആയിരിക്കുമ്പോൾ 2 കമ്മിറ്റികൾ രൂപീകരിക്കപ്പെടുകയുണ്ടായി. ഒരു കമ്മിറ്റി കോൺസ്റ്റിറ്റ്യൂഷന്റെ ഫംഗ്ഷനിങ് പഠിക്കുന്നതിന് വേണ്ടി രൂപീകരിച്ചിരുന്ന കമ്മിറ്റിയാണ് ജസ്റ്റിസ് വെങ്കട ജല്ലയ്യ കമ്മിറ്റി. ആ കമ്മിറ്റി വളരെ വിശദമായ റിപ്പോർട്ട് സമർപ്പിച്ചിരുന്നു. നമുക്കറിയാം എക്സിക്യൂട്ടീവ് അത് ആക്സെപ്റ്റ് ചെയ്തിരുന്നില്ല. 2000 തന്നെ the same government had constituted another committee, that is Justice Malimat Committee, to submit the recommendation for the reforms of the criminal law in our country. എനിക്ക് തോന്നുന്നു ഒരു more than 150 recommendations ആ കമ്മിറ്റിയും സബ്മിറ്റ് ചെയ്തിരുന്നു. അതിൽ ചിലതെല്ലാം പല രൂപത്തിൽ അഡ്മിറ്റ് ചെയ്യപ്പെട്ടിട്ടുണ്ട്. പക്ഷെ എപ്പോഴൊക്കെ BJP രാജ്യത്തിന്റെ അധികാരത്തിൽ വന്നിട്ടുണ്ടോ അപ്പോഴെല്ലാം നിലവിലുള്ള നിയമവ്യവസ്ഥയെ മാറ്റി തീർക്കുന്നതിനുള്ള ശ്രമങ്ങൾ നടന്നിട്ടുണ്ട് എന്നതാണ് ഗൗരവമായി നമ്മൾ കാണേണ്ട ഒന്നാമത്തെ ഭാഗം എന്നുള്ളത്. അത് ഈ ഘട്ടത്തിലും കാണാം, നേരത്തെയുള്ള ഘട്ടത്തിലും കാണാൻ കഴിയും. പൊതുവായ ഒരു കാഴ്ചപ്പാടോടുകൂടി ഇത്തരം പരിഷ്കാരങ്ങൾ വരുന്നുവെങ്കിൽ നമ്മളത് സ്വാഗതം ചെയ്യേണ്ടതാണ്. ഇതെല്ലാം കൊളോണിയൽ കാലഘട്ടത്തിലെ നിയമങ്ങളാണ്. എന്നാൽ കൊളോണിയൽ കാലഘട്ടത്തിലുള്ള ഒരു വിക്ടോറിയൻ ധാർമ്മികത പോലും ഇല്ലാത്ത രൂപത്തിലുള്ള പരിഷ്കാരങ്ങളിലേക്കാണ് ഇപ്പോൾ വരുന്നതെങ്കിൽ അത് അപകടകരമായിട്ടുള്ള അവസ്ഥയിലേക്ക് നമ്മുടെ സമൂഹത്തെ കൊണ്ടുപോവുക മാത്രമായിരിക്കും ചെയ്യുക. ഇപ്പോഴത്തെ കമ്മിറ്റിയുടെ പ്രശ്നം ആരോ പറഞ്ഞതുപോലെ 5 members from Delhi, they are trying to change the criminal law system in our country. 5 പേര് ഡൽഹിയിൽ ഇരുന്നിട്ട് ഇന്ത്യയിലെ നിയമവ്യവസ്ഥയെ മൊത്തത്തിൽ മാറ്റാൻ ശ്രമിക്കുകയാണ് എന്നുള്ളതാണ്. ഈ നമ്മുടെ പാർലമെന്റിന്റെ പ്രത്യേകത അത് ഡെമോക്രാറ്റിക്കലി എലക്റ്റഡ് പാർലമെന്റ് ആണ്. കോൺസ്റ്റിറ്റ്യൂവന്റ് അസംബ്ലിക്ക് അത്രയും ഒരു സവിശേഷത ഉണ്ടായിരുന്നില്ല. അത് തെരഞ്ഞെടുക്കപ്പെട്ടവരാൽ തെരഞ്ഞെടുക്കപ്പെട്ട ഒരു സംവിധാനമായിരുന്നു. ഇവിടെ രൂപീകരിക്കപ്പെട്ട ഈ 5 അംഗ സമിതി എന്നുള്ളത് അതിൽ പ്രധാനമായും അക്കാഡമിഷ്യന്മാരാണ്. ഡൽഹി നാഷണൽ ലോ യൂണിവേഴ്സിറ്റിയുടെ കാഴ്ചപ്പാട്. നാഷണൽ ലോ യൂണിവേഴ്സിറ്റി തന്നെ ഈ കമേഴ്സ്യലൈസേഷൻ ഓഫ് എഡ്യൂക്കേഷൻ, കമേഴ്സ്യലൈസേഷൻ ഓഫ് ലീഗൽ സിസ്റ്റം, ആ ഒരു പ്രത്യേക കാഴ്ചപ്പാടോടുകൂടി രൂപം കൊണ്ട ഒരു സംവിധാനമായിട്ടാണ് പൊതുവെ പരിഗണിക്കപ്പെടുന്നത്. അപ്പൊ അങ്ങനെയുള്ള ഒരു എലൈറ്റ് ക്ലാസിൻ്റെതായിട്ടാണ് സാധാരണ NLU കൺസിഡർ ചെയ്യാറുള്ളത്. അപ്പൊ അവരാണ് പ്രധാനപ്പെട്ട അതിന്റെ VC രജിസ്ട്രാർ ഇങ്ങനെയുള്ളവരാണ് പ്രധാനപ്പെട്ട ആളുകൾ. ഒരു സീനിയർ ലോയർ ഉണ്ടെന്ന് പറയാം, വേണമെങ്കിൽ റിട്ടയർ ചെയ്ത ഒരു ഡിസ്ട്രിക്ട് ജഡ്ജി ഉണ്ടെന്ന് പറയാം. അങ്ങനെ 5 പേരിലേക്ക് മാത്രമായി അത് പരിമിതപ്പെട്ടിരിക്കുന്നു. അപ്പോൾ സമൂഹത്തിൽ ഒരു ക്രോസ് സെക്ഷൻ ഇറ്റ് ഇസ് നോട്ട് റിഫ്ലക്റ്റഡ് ഇൻ ദിസ് കമ്മിറ്റി. ഈ കാലഘട്ടത്തിൽ വിത്തൗട്ട് എ സിംഗിൾ റെപ്രസെന്റേഷൻ ഫ്രം ദ വുമൺ കമ്മ്യൂണിറ്റി എങ്ങനെയാണ് ഒരു ലോ റിഫോംസിനെ കുറിച്ച് ചർച്ച ചെയ്യാൻ കഴിയുന്നത്? ഭരണഘടനാ അസംബ്ലിയിൽ നടന്ന ചർച്ചയിൽ സ്ത്രീകൾക്ക് സംവരണം വേണമെന്ന് പറഞ്ഞപ്പോൾ അന്ന് വന്നൊരു വാദം, സ്ത്രീകൾ ഹൃദയം കൊണ്ടാണ് ചിന്തിക്കുന്നത്, പുരുഷന്മാർ ബുദ്ധി കൊണ്ടും. അതുകൊണ്ട് സ്ത്രീകൾക്ക് അങ്ങനെ സംവരണത്തിന്റെ ആവശ്യമില്ല, ഭരണം ബുദ്ധി കൊണ്ട് നിർവഹിക്കേണ്ടതാണ്. ഇതായിരുന്നു അന്നത്തെ ഒരു വാദം. അത് കഴിഞ്ഞിട്ട് എത്രയോ കാലമായി. ഇപ്പോഴൊരു കമ്മിറ്റിക്കകത്ത് ഒരു സിംഗിൾ റെപ്രസെന്റേഷൻ പോലും ഇല്ലാതെ, ഒരു വുമൻ റെപ്രസെന്റേഷൻ പോലും ഇല്ലാത്തൊരു കമ്മിറ്റി, മൈനോറിറ്റി റെപ്രസെന്റേഷൻ ഇല്ല, മാർജിനലൈസ്ഡ് കമ്മ്യൂണിറ്റിയുടെ റെപ്രസെന്റേഷൻസ് ഇല്ല. അത് സോഷ്യലി ആകാം, എക്കണോമിക്കലി ആകാം. അപ്പൊ അങ്ങനെ ഒരു റെപ്രസെന്റേഷൻ ഇല്ലാത്ത ഒരു കമ്മ്യൂണിറ്റി ഇന്ത്യയുടെ ഈ ഒരു ക്രോസ് സെക്ഷൻ അല്ല, റിഫ്ലക്ട് ചെയ്യുന്നില്ല. അപ്പൊ അതുകൊണ്ട് ഈ കമ്മിറ്റിയെ തന്നെ മാറ്റുക എന്നതാണ് ഒന്നാമത്തെ ഫസ്റ്റ് ഡിമാൻഡ്, അതായിരിക്കണം എന്നുള്ളതാണ്. ഈ കമ്മിറ്റിക്ക് ഈ ദൗത്യം വളരെ ദുഷ്കരമായ ദൗത്യമാണ്. നൂറ്റാണ്ടുകളുടെ പഴക്കമുള്ള IPCയും അതുപോലെ എവിഡൻസ് ആക്ടും പിന്നെ തുടർച്ചയിൽ പുതുക്കി വന്ന CRPCയും ഇത് മാറ്റിയെടുക്കുക എന്നുള്ളത് ഒരു വലിയ ദുഷ്കരമായ ദൗത്യമാണ്. ആ ദൗത്യ നിർവഹണത്തിൽ ഇപ്പോ നിയോഗിച്ചിട്ടുള്ള കമ്മിറ്റിയുടെ ഘടന മാറ്റണം. അതായിരിക്കണം ഒന്നാമത്തെ സ്ലോഗനം തന്നെയാണ് എനിക്ക് തോന്നുന്നത്. ഇന്നലെ ഞാനും പ്രമോദും മറ്റൊരു സെമിനാറിൽ സംസാരിച്ചതിന് ശേഷം അയച്ചു തന്ന ക്വസ്റ്റ്യനെയറുകൾ പ്രമോദ് എന്നോട് ഷെയർ ചെയ്യുകയുണ്ടായി. യഥാർത്ഥത്തിൽ ഈ ക്വസ്റ്റ്യനെയറുകൾ തന്നെ പ്രിപ്പയർ ചെയ്യേണ്ടത് ഇങ്ങനെ ആകരുത് എന്നുള്ളതാണ്. ആ ക്വസ്റ്റ്യൻസ് തന്നെ ഈ പ്രശ്നത്തെ എങ്ങനെ അഡ്രസ് ചെയ്യുന്നു, ഈ നൂറ്റാണ്ടുകൾ കൊണ്ട് ഇന്റർനാഷണൽ ആയിട്ടുള്ള പെർസ്പെക്റ്റീവ് മാറിയിട്ടുണ്ട് ക്രിമിനൽ ജസ്റ്റിസ് സിസ്റ്റത്തിൽ. ആ മാറ്റത്തിനനുസരിച്ച് എന്തെല്ലാം റിഫോംസ് വന്നിട്ടുണ്ട് ഇന്റർനാഷണലി. അതിന്റെ അടിസ്ഥാനത്തിൽ ഏതെല്ലാം ക്വസ്റ്റ്യൻസ് ആണ് നമ്മൾ ഇപ്പോൾ അഡ്രസ് ചെയ്യേണ്ടത്. അത്തരത്തിലുള്ള ഒരു സമീപനം ഈ ക്വസ്റ്റ്യനെയർ തയ്യാറാക്കുന്നതിൽ തന്നെ വേണ്ടത്ര ഉണ്ടായിട്ടില്ല എന്നാണ് എനിക്ക് ഒന്ന് ഓടിച്ചാൽ നോക്കിയിട്ടുള്ളൂ. ഞാൻ നേരത്തെ പറഞ്ഞല്ലോ, ഐ നോട്ട് ആൻ എക്സ്പെർട്ട് ഇൻ ക്രിമിനൽ ലോ. അത് ഇപ്പോ ബാക്കി നിങ്ങൾ പറയും. ആ ക്വസ്റ്റ്യൻസ് നോക്കുമ്പോൾ തന്നെ അതൊരു കോംപ്രഹെൻസീവായി ഈ പ്രശ്നത്തെ അഡ്രസ് ചെയ്യുന്നില്ല. വളരെ വേഗമാണ് ഇവരുടെ അർപ്പിതമായ ദൗത്യം. വളരെ വേഗമായി, വളരെ ഒരു ഹെർക്കുലിയൻ ടാസ്ക് 6 മാസത്തിനുള്ളിൽ പാൻഡമിക്കിന്റെ സന്ദർഭത്തിൽ നിർവഹിച്ചു കൊടുക്കുക എന്ന് പറഞ്ഞാൽ, നേരത്തെ പ്രിപ്പയർ ചെയ്ത് വെച്ച റിപ്പോർട്ട് സബ്മിറ്റ് ചെയ്യാനാണെങ്കിൽ ഇറ്റ് ഈസ് ഇനഫ് ആൻഡ് മോർ. അതാണ് നേരത്തെ ഒരു പ്രിപ്പയർ ചെയ്തിട്ടുണ്ട് ഒരു റെക്കമെൻഡേഷൻ എങ്കിൽ ഈ സമയം വേണ്ടി വരില്ല. ഇത്രയും ഒരു ക്വസ്റ്റ്യനെയർ മറ്റ് ഒരു കൺസൾട്ടേഷൻ പ്രോസസ്സും I think it is required if they are already prepared the report to be submitted. എങ്കിൽ it is okay. ഇവിടെ അങ്ങനെ അല്ലെങ്കിൽ ഈ കമ്മിറ്റി റീകോൺസ്റ്റിറ്റ്യൂട്ട് ചെയ്യണം. This committee should reflect the cross section of Indian society. It should give representation to the women and other marginalized sections of the society, economically, socially, and this transgender community also. അപ്പൊ അത്തരത്തിലുള്ള കാര്യങ്ങൾ ഇതിനകത്ത് വരേണ്ടതുണ്ട്. പിന്നൊന്ന് ഇപ്പോൾ നമ്മുടെ മുൻപിലുണ്ട് വർമ്മ കമ്മിറ്റി. അത് റേപ്പിനെ സംബന്ധിച്ച് വന്നിട്ടുള്ള വളരെ ചെറിയ ഒരു ഫ്രെയിം വർക്കിൽ ഒറ്റ ക്വസ്റ്റ്യൻ തന്നെ അഡ്രസ് ചെയ്ത കമ്മിറ്റിയാണ്. അപ്പൊ അതിന്റെ ഒരു പ്രോസസ് ഉണ്ട്. അതിനകത്ത് ചില വ്യത്യസ്തതകളൊക്കെ ഉണ്ടായിരുന്നെങ്കിൽ പോലും ഒരു പ്രോസസ് ഉണ്ട്. അപ്പൊ അത്തരത്തിലുള്ളതൊന്നും തന്നെ ഇതിനകത്ത് പിന്തുടരുന്നില്ല. പൊതുവെ വരുന്ന നിഗമനങ്ങൾ സാധാരണഗതിയിൽ ക്രിമിനൽ ലോയ്ക്കകത്ത് കാണുന്നത് 1000 കുറ്റവാളികൾ രക്ഷപ്പെട്ടാലും ഒരു നിരപരാധി ശിക്ഷിക്കപ്പെടരുത് എന്നുള്ളതാണ്. അപ്പൊ അതിൽ നിന്ന് വ്യത്യസ്തമായ ഒരു കാഴ്ചപ്പാടിലേക്ക് വരുന്നത് പ്രിസംപ്ഷൻ ഓഫ് ഇന്നസെൻസ്. അത് ക്രിമിനൽ ലോയുടെ പ്രധാനപ്പെട്ട ഭാഗമാണ്. ദെൻ ദ പ്രിൻസിപ്പിൾ ഓഫ് ഈക്വാലിറ്റി ബിഫോർ ദ ലോ, അതും പ്രധാനപ്പെട്ടതാണ്. നേരത്തെ ഇവിടെ പറഞ്ഞ നോൺ അഡ്മിസിബിലിറ്റി ഓഫ് ദ സ്റ്റേറ്റ്മെന്റ് മെയ്ഡ് ബിഫോർ ദ പോലീസ് ആൻഡ് റെസ്ട്രിക്ഷൻ ഓൺ അഡ്മിസിബിലിറ്റി ഓഫ് ഇൻക്രിമിനേറ്റിംഗ് എവിഡൻസ് ഒബ്റ്റെയിൻഡ് ഫ്രം സെർച്ച് ആൻഡ് സീസർ. ഇതെല്ലാം ഒരു ഇന്റഗ്രൽ പാർട്ട് ഓഫ് ദ പർപ്പസ് ഓഫ് ക്രിമിനൽ ലോ ആണ്. അപ്പൊ ആ പെർസ്പെക്റ്റീവിൽ മാറ്റം വരുന്നുണ്ട്. സാധാരണ പറഞ്ഞ അക്യൂസ്ഡിന് ആണ് കൂടുതൽ താല്പര്യം, അതിലേക്കാണ് പെൻഡുലം പോകുന്നത്. വിക്ടിംസിലേക്കുള്ള പെൻഡുലത്തിന്റെ മറ്റൊരു ഇതിലേക്കുള്ള യാത്രയാണ് എന്നെല്ലാം പറയുന്നുണ്ടെങ്കിലും യഥാർത്ഥത്തിൽ ഒരു നാച്ചുറൽ ജസ്റ്റിസിനെതിരായി വരുന്നതിലേക്കാണ് നമ്മുടെ അനുഭവങ്ങൾ. പ്രത്യേകിച്ചും ഇന്ത്യൻ സാഹചര്യം ഇപ്പൊ കാണല്ലോ, രാജ്യത്ത് ആദ്യമായിട്ടാണ് നമുക്ക് യൂണിഫോം സിവിൽ കോഡ് ഇല്ല, പക്ഷെ യൂണിഫോം ക്രിമിനൽ കോഡ് ഉണ്ട്. പക്ഷെ യൂണിഫോം ക്രിമിനൽ കോഡ് നിലനിൽക്കുമ്പോഴാണ് മതത്തിന്റെ അടിസ്ഥാനത്തിൽ ഒരു ക്രിമിനൽ നിയമം ഈ ഗവൺമെന്റ് ഇന്ത്യയിൽ കൊണ്ടുവന്നത്. അതാണ് മുത്തലാഖ് നിയമം എന്നുള്ളത്. ഫസ്റ്റ് ടൈം ഇൻ ദ ഹിസ്റ്ററി ഓഫ് ഇൻഡിപെൻഡന്റ് ഇന്ത്യ, എ ക്രിമിനൽ ലോ ഓൺ ദ ബേസിസ് ഓഫ് റിലീജിയൻ, ദാറ്റ് ഈസ് മുത്തലാഖ് ആക്ട്. ഡൈവേഴ്സ് ഒരു സിവിൽ പ്രശ്നമാണ്, പക്ഷെ അത് ക്രിമിനലായി മാറി. അത് മതത്തിന്റെ അടിസ്ഥാനത്തിൽ ഓൺലി ഫോർ മുസ്ലിംസ്. അപ്പോ ആ ഒരു ഡിസ്ക്രിമിനേഷൻ എന്നുള്ളത് സെക്കൻഡറി സിറ്റിസണായി മുസ്ലിം മൈനോറിറ്റി, അതുപോലെ ഹിന്ദു വിഭാഗത്തിനകത്ത് തന്നെയുള്ള അവർണർ, ഇവരെയെല്ലാം പരിഗണിക്കപ്പെടുന്ന മനുസ്മൃതിയുടെ കാഴ്ചപ്പാട്, അത് അന്ന് കോൺസ്റ്റിറ്റ്യൂഷൻ അംഗീകരിച്ചതിന് ശേഷം എഴുതിയ എഡിറ്റോറിയലിൽ RSSന്റെ മുഖപത്രം പറയുകയുണ്ടായി, ഹിന്ദുവിനെ സംബന്ധിച്ചിടത്തോളം മനുസ്മൃതി തന്നെയാണ് അവർ കോൺസ്റ്റിറ്റ്യൂഷൻ. അതിനനുസരിച്ചു കൊണ്ടുള്ള പുതുക്കിപ്പണികലുകളാണ് നമ്മുടെ രാജ്യത്ത് ഇപ്പോൾ നടത്താൻ ശ്രമിക്കുന്നത്. ആ ഒരു കാഴ്ചപ്പാട് ഈ ക്രിമിനൽ ലോ അമെൻഡ് ചെയ്യുമ്പോഴും ഉള്ളടക്കം ചെയ്യപ്പെടും എന്നുള്ള ഭീതിയാണ് വളരെ പ്രശസ്തരായ ആളുകൾ എല്ലാ മേഖലയിൽ നിന്നും പ്രകടിപ്പിച്ചിട്ടുള്ളത്. പക്ഷേ ഇന്ത്യൻ സമൂഹം വേണ്ടത്ര ഗൗരവത്തോടു കൂടി ഇത് ചർച്ച ചെയ്തിട്ടില്ല എന്നതാണ് യാഥാർത്ഥ്യം. ഈ മേഖലയ്ക്ക് അക്കാദമികമായ മേഖലയ്ക്കകത്തുള്ള കൺസൾട്ടേഷൻ നടന്നുകൊണ്ടിരിക്കുന്നുണ്ട് യൂണിവേഴ്സിറ്റികൾക്കകത്ത്. ജുഡീഷ്യറിയിൽ നിന്ന് റിട്ടയർഡ് ജഡ്ജസിന്റെ ചില പ്രതികരണങ്ങൾ വന്നിട്ടുണ്ട്, ബാർ അസോസിയേഷനുകളിൽ ചില പ്രതികരണങ്ങൾ വന്നിട്ടുണ്ട്, ലോയേഴ്സ് പ്രതികരണം വന്നിട്ടുണ്ട്. പക്ഷേ ഈ ക്രിമിനൽ ലോയുടെ അമെൻമെന്റ് ഇറ്റ് ഈസ് നോട്ട് ഓൺലി അപ്ലിക്കബിൾ ടു ദിസ് ബാർ ആൻഡ് ബെഞ്ച്, ഇറ്റ് ഈസ് അപ്ലിക്കബിൾ ടു ദ സൊസൈറ്റി അറ്റ് ലാർജ്. അത് രാജ്യത്താകെ ബാധിക്കുന്നതാണ്. അതല്ലാണ്ട് അഭിഭാഷക സമൂഹത്തിന്റെ പ്രശ്നമല്ലത്. അത് രണ്ട് അക്കാഡമിഷ്യന്മാരും ഒരു റിട്ടയർഡ് ഡിസ്ട്രിക്ട് ജഡ്ജും ഒരു സീനിയർ ലോയറും കൂടി കൈകാര്യം ചെയ്ത് തീർക്കേണ്ട പ്രശ്നമല്ലത്. സമൂഹത്തിന്റെ, പൊതുസമൂഹത്തിന്റെ ശക്തമായ ഇടപെടൽ ആവശ്യമാണ്. ആ രൂപത്തിലേക്ക് നമ്മുടെ പബ്ലിക് ഒപ്പീനിയനകത്തേക്ക് ഇത് വന്നിട്ടില്ല എന്നുള്ളതാണ്. അധികം ആളുകൾ അറിയുന്നില്ല ഇങ്ങനൊരു പ്രക്രിയ, പ്രോസസ് ഇസ് ഗോയിങ് ഓൺ ഇൻ അവർ കൺട്രി എന്നുള്ളത് അധികം ആളുകൾ അറിയുന്നില്ല. അപ്പൊ അതുകൂടി മനസ്സിലാക്കിക്കൊണ്ട് നന്നായി പ്രവർത്തിക്കാൻ ഐലുവിന് കഴിയേണ്ടതുണ്ട്. എനിക്ക് തോന്നുന്നു ഈ സെമിനാർ അതിന്റെ തുടക്കമാകും. അതിന് മുൻകൈയെടുത്ത ജില്ലാ കമ്മിറ്റിയെ ഈ സന്ദർഭത്തിൽ ഞാൻ പ്രത്യേകം അഭിനന്ദിക്കുന്നു. വളരെ പ്രശസ്തരായ ആളുകൾ അവരോട് സംസാരിക്കും എന്നുള്ളത് കൊണ്ട് മറ്റു കാര്യങ്ങളിലേക്ക് പോകണമെന്ന് ഞാൻ കരുതുന്നില്ല. അവരുടെ പ്രഭാഷണങ്ങൾ ഇതിനകത്ത് പുതിയ വെളിച്ചം പകരും എന്ന പ്രതീക്ഷയോടുകൂടി നിങ്ങളുടെ ഈ വെബിനാർ ഉദ്ഘാടനം ചെയ്തതായി അറിയിച്ചുകൊണ്ട് ഞാൻ എൻ്റെ വാക്കുകൾ അവസാനിപ്പിക്കുന്നു. എല്ലാവർക്കും അഭിവാദ്യങ്ങൾ. ദിനേശ് അൺമ്യൂട്ട് ചെയ്താലേ കേൾക്കുള്ളൂ. ദിനേശ് അൺമ്യൂട്ട് ചെയ്യണം.
I thank Advocate P Rajeev for his inaugural address and giving us a support against this committee formed for criminal reforms. We have two speakers today, Advocate S. Balan, senior criminal lawyer from Karnadaka, who had led many campaigns against this criminal reform committee 2020. We have our state secretary Pramod, Advocate Pramod. He also is having in-depth knowledge in this criminal reforms 2020 and its constitution. Now I request Advocate S. Balan to address this gap and share views about criminal law reforms 2020.
Thank you for the university. Am I audible?
You're audible. You're audible.
Yeah.
Yes, you are audible.
Yes. Thank you for the invitation. Criminal Law Reforms Committee. Since the month of August 2019, at the 54th conference of DGP, IGP held in Pune, Home Minister Amit Shah expressed his desire and vision to achieve $5 trillion economy. Also to effectively implement CAA, NRC, NPR. He raised the issue of Babri Masjid as well as Article 370 and 35A of the Constitution. He said that there must be a strong and effective criminal law. So initially he tasked Bureau of Police Research and Development to initiate process of drafting to that effect. And he changed his mind. Rather, Home Ministry changed its mind. And it was tasked to a 5-member committee at Delhi, as Mr. Rajeev pointed out, 2 vice chancellors, 1 retired judge, 1 registrar of the university, and a lawyer from Maharashtra. So he's also a spokesperson of a ruling dispensation. A 5-member committee to reboot, recast, rewrite, revamp, reform, overall, the three major criminal acts: Evidence Act, IPC, and CRPC. There are various dimensions to this due to time constraint. I only going to concentrate on its basic and fundamental tenets of the state policy on criminal law. See, it is time and again held that the golden rule runs through the web of civilized criminal justice system. Number one, presumption of the innocent till the guilt is proved. This is number one. Number two, a right to silence, right against self-incrimination. This is number two. Then burden of proof, proof beyond shadow of doubt shall be established by the prosecution. Then comes documentation, 15 days initial custody, it could be police custody or judicial custody. Thereafter, up to 90 days. Then the entire charges that are framed, the documents that are filed with the charge sheet are required to be furnished to the accused as a matter of right. This otherwise called as the fair trial. This fair trial was declared in the Article 14 of the International Covenants on Civil and Political Rights. Article 14 says, all persons shall be equal before the courts and tribunals. Number two, everyone charged with a criminal offense shall have the right to be presumed innocent until proven guilty according to the law. Article 14G, not to be compelled to testify against himself or to confess it. Everyone to be informed promptly and in detail in a language which he understands. To have free assistance of interpreter. The same thing was reiterated in Universal Declaration of Human Rights under Article 10. Right against self-incrimination under Article 11. Article 6 of European Convention on Human Rights. Then Article 6 of American Law Amendment. So this is the internationally accepted concept of fair trial, which has been cherished in Indian criminal justice system. So then we go back to 1950 Constitution, Article 20, Clause 3, right of silence, right against self-incrimination. Article 21, due process of law. Article 14, equality before law. This is constitutional principles. Then go beyond that during the debate on 4th November 1948. Dr. Babasaheb Ambedkar pointed out that the democratic form of government reflects in the criminal justice system. So the criminal justice system, the concept discussed was in the Constituent Assembly, a fair trial. It doesn't stop there. It again goes back to Evidence Act 1872. Evidence Act as an history of drafting over a period of 100 years. It began in the year 1794. It culminated in the form of an act Indian Evidence Act in the year 1872. The most important sections, right against self-incrimination, section 24 to 26 of the Evidence Act. So nobody can be compelled to be no confession through threat or coercion. Statement or confession made before police prior to arrest is inadmissible. Statement made before police after arrest is inadmissible. Followed by that, there are thousands of judgments. Historical judgments in Privy Council. Agnu Nagesha versus State of Bihar. Pulukuri Kotaya's case. Then Kashmira Singh's case. These are all the landmark judgments in the concept of fair trial. This fair trial concept accepted internationally, accepted in India, time tested and cherished by various judicial pronouncement, was deviated in the year 1985 when Tada Act was enacted. So this Article 20 Class 3 was blunted in Tada. Section 15, confession statement made before the police officer not below the rank of SP became admissible in evidence. That was challenged before the Supreme Court in Kartar Singh case. A dissent judgment was written by Justice Ramaswamy. He said this is unconstitutional. It is not only unconstitutional, against the principles of civilized criminal justice system internationally accepted. But the other two bench decided otherwise. They said the accused in Tada are a class apart. So equality before law. Article 19, Article 21 is not applicable to them. Tada ruled 10 years, though the sunset class was for 2 years. Lakhs of people, even ordinary criminals, were roped in this draconian Tada Act. Many were hanged, including Afzal Guru, Yaqub Memon. What is the evidence against them? It is evidence scripted by the police officials in the form of confessional statement. That was admissible in evidence. Normally, it has no value at all. 1995, it got repealed. Then again, 2002, photo was enacted. In the Photo Act, section 15 of Tada was retained under section 32 of Photo Act. Again, the same draconian law. Though Tada was repealed, the concept, the structure, scheme and scope of Tada has been retained by various states in the form of Karnataka Organized Control of Crime Act, Maharashtra Organized Control of Crime Act, Chhattisgarh Special Powers Act, Gujarat Special Powers Act. Though Tada was repealed, it was detained against those laws or anti-international covenants, unconstitutional. Then photo. See, we all know that in the year 2000, when Atal Bihari Vajpayee was the Prime Minister and Elka Advani was the Home Minister, they constituted a committee called V.S. Malimat Committee. Malimat was the then Chief Justice of Karnataka High Court as well as Kerala High Court. He made a study, he made a research and submitted a report in the year 2003 before Home Minister L.K. Advani. Then he rebooted the whole concept, structure, scheme, and scope of fair trial, rebooted, revamped, recasted, reformed, overhauled in the form of 158 recommendations. What are all the recommendations made by V.S. Malimat? Number 1, Article 20, Class 3, right against self-incrimination. Nobody shall be testified to be a witness against himself or herself. That should be given go by. That article should be removed from the constitutional. Then he said section 24 to 30 of 26 of evidence should give a go by. Confessional statement or statements made before the investigating agency prior to after arrest of an accused person should be made as evidence on par with 161 statement. That is number 1. Number 2, burden of proof, reverse burden. So the prosecution need not prove this beyond shadow of doubt, just preponderance of probability. If there is some material and the judge feels that it is true, the conviction, the reverse burden, that is second. Then sealed cover. Sealed cover witness means the name and address of the witnesses, whether it's a Caesar witness or an eyewitness, that will be concealed. He recommended that the session judge or a trial judge shall be bestowed with the power of summoning any person as a witness, though not shown in the charge sheet. Any summons. Then the judge should also be bestowed with the power of cross-examining the accused to elucidate answers. If the accused remains silent, then the court can draw adverse inference. Then what happened? Remand of 15 days should be converted into 30 days. So in ordinary criminal law also, 30 days initial remand. It could be police custody or judicial custody. Then period of remand shall be extended up to 180 days. So entire general criminal law, Justice V.S. Malimat wanted to be draconian. That is the hidden agenda. So this they materialized, the concept of V.S. Malimat, they materialized by incorporating section 32 in footer in the year 2002. Confession made before the police is admissible in evidence. Justice Malimat also recommended that there must be a central investigating agency other than the state agency, besides CBI. This was another recommendation. See, based on his recommendation, Unlawful Activities Prevention Act was amended in the year 2004. There are two sections. One is 43E of UAP Act and section 38 of UAP Act. 38 speaks about member of a unlawful association or terrorist gang or terrorist organization. If the investigating agency declares a person as a terrorist, burden is on the accused to disprove that he was not a member of any terrorist organization. Reverse burden. That was the concept of V.S. Malimat. Then section 43E punishment up to death or life imprisonment. Such a death punishment could be given based on adverse inference. The prosecution need not prove it beyond shadow of doubt. Burden shifted, reverse burden. So 43 of UAPA, 38 of UAPA, 15 of TADA, 32 of POTA. Now they wanted to bring it in general law. This was the whole structure, fundamentals, scheme and scope of Justice V.S. Malimat Committee report. So incidentally, that was a committee constituted by the present ruling dispensation or ruling clique in the year 2003. Committee constituted in the year 2000. Fortunately, they lost election in the year 2004. Manmohan Singh, UPA 1 and UPA 2, 10 years, they were out of power. Therefore, the Malimat Committee report was kept in abeyance. The Malimat Committee prima facie indicates the entire criminal justice system, civilized criminal judicial system, internationally accepted criminal jurisprudence to be converted as a fascist, uncivilized, draconian, anti-people, anti-constitutional system that was kept in abeyance. Then 2014, they have no majority in the Rajya Sabha. Now 2019, see the hidden agenda is to create an authoritarian state. While addressing the same conference of IGP, DGP, Home Minister Amit Shah declared, once a charge sheet is filed with forensic evidence, no scope for the presiding officer and no scope for the defense lawyer. You want conviction to be more. The very scope and scheme of constituting this 5-member committee is to increase conviction rate, to bring an authoritarian state, to bring a police Raj, which is in violation of Article 14, 19, 20, Class 3, 21 of the Indian Constitution. The fundamental tenets of constitutional provisions, fundamental tenets of international covenants of political and civil rights, Universal Declaration of Human Rights, internationally accepted concept of civilized criminal justice system they want to go by. Now what they say, fruits from poisonous tree, what it means? Whatever mode the investigating agency collects evidence, that is admissible. Fruits from poisonous tree. Forcefully, unreasonably, unconstitutionally, illegally collected evidence can be pressed into service to commit a person to death sentence. That is the structure which they propose. Then see, every criminal offense, mens rea, actus reus, criminal intention and an act, both should be proved beyond shadow of doubt. Now they wanted to remove the concept of mens rea. They also wanted to remove the concept of actus reus. Already in UAPA Act, no value for mens rea. No scope for actus reus. Just a presumption is enough to convict a person. That is what I said, 43E and 38 of UAP Act. That is incorporated in the form of 32 of photo 15 of Tata and various state laws. So now they wanted to completely recoup, revamp the entire cherished criminal justice system, cherished for the last 150 years, in the name that these are all colonial law. Colonial law or international law, any criminal jurisprudence, the advocates who are interested in the broader society, a egalitarian society, a equal society, a rule of law, we all know that the law belongs to people. It is not belonging to any corporate, communal ganger. It is for the people, those who believe in the people's law. There cannot be compromise of presumption of innocence. There cannot be compromise on right against self-incrimination. There cannot be a compromise against making a person to testify against himself. There cannot be a compromise against proof beyond shadow of doubt. There cannot be a compromise that all charge-sheeted material shall be supplied to the accused pre-hand. It must be open trial. It can't be in-camera proceeding. Every trial must be fair. Every trial must be open. And there must be a fair trial on par with internationally accepted concept. Okay, coming to this committee, as Mr. Rajeev pointed out, what is the necessity of constituting this committee when the whole country is shut down, when the courts are shut down, when the people's attentions are diverted somewhere? What is the necessity? What is the hidden agenda? Why this was constituted on 4th of May, when the whole country was under shutdown, when the courts were completely shut down, when people were busy in something else and they were starving? What is the necessity to constitute? And questionnaire they prepare, it is like a first year law student questionnaire. Nothing is there. The major hidden agenda in the questionnaire I have prepared by them, just picked up from Justice V.S. Malimat Committee report. And it is only in English language. We all know. As per 2011 statistics, only 10% of the Indians could able to understand and speak English. Out of 134 crores Indians, 120 crore Indians can't speak English. See, this is not just a connection between the advocates and the court. It affects minorities, it affects Dalits, it affects Adivasis, it affects workers, it affects transgender, it affects every section of the society. Criminal law is a bigger connection between the state and the people. Ultimately, it is the people who go to jail. And where is the representation for women? V.S. Malimat Committee report is totally anti-woman. His recommendation was that even in an adultery case, even women should be punished. His recommendation was Dowry Prohibition Act should be made compoundable and bailable. Dilution of rape laws. It is against women. Now, why the committee has not included a woman scholar, woman lawyer, woman activist? Why they have not incorporated? By and large, it affects minorities. It is they who are incarcerated in various prisons in thousands under UPA, under various acts, section 122, 130 of Indian Penal Code. It is there. Why this central government did not incorporate a representative from minorities? Dalits, they face the wrath. They are also in jail. Why Dalits are not made as a member of the committee? Adivasis who lost their rights in the forests, mountains, tank beds, river beds, why they were not incorporated into this committee? Why the workers and trade unions are not made as member of this committee? Why not a trial lawyer? It's only delayed. What about Northeast? What about South? What about Central India? Why only delayed? What is the hidden agenda? See, normally Law Commission used to make recommendation. Why task was not given to the Law Commission? Why task was not given to a expert panel led by a sitting or retired Supreme Court judge? Why university who never practiced in any court? Why Ranbir Singh is made as chairman of this committee? And is it possible to revamp, reboot entire three major acts which are very interconnected? Trial lawyers know. What is the difficulty? See, the days were gone. The concept of benefit of doubt was taken away by various ratios set down by the Supreme Court and the High Court. Still, we are managing to get relief to innocent who are framed into the case. What sort of police we have? Satankulam, Uttar Pradesh, Madhya Pradesh. What sort of police system you have? Why this government wanted to strengthen the hands of the law enforcement agency who are otherwise called as law keeper? Then we are doubtful of the nexus between the lawmaker, law keeper and the lawbreaker. Why this was interested to that committee? What is their hidden agenda? Therefore, this committee should be dissolved. We don't accept this committee. This committee should go. This committee has no locus standi to prepare questionnaire. This committee is illegal. This committee is dictated by certain political interests. Never in the history of lawmaking, the task was entrusted to a university professors. Never in the history. It should go to an expert panel who has knowledge over the criminal jurisprudence. This committee is unacceptable. This committee should go. And never it should be entrusted to a university. There is no quarrel. Sir, what the point I make, the first law commission under the leadership of Thomas Bellington Macaulay, it took almost 34 years to draft Indian Penal Code. 34 years. To draft a Criminal Procedure Code, it took almost 42 years. To make an Indian Evidence Act, it took almost 100 years. Various meetings, various deliberations. It was printed and circulated to all the high courts, all the courts. Such a laborious work was undertaken. I don't say Macaulay He's an Indian. He was a foreigner. He's a colonial master. He was the ideologue of British imperialism. Yes, but still fair trial. Even that concept you wanted to remove, then what is your new concept? You bring it from Germany, France. So nothing is their own. They wanted to push the country about 400, 500 years back. Then it would be a general Raj, police Raj. The common man will not get justice if it is rebooted. Therefore, this committee should go, number one, reconstitution of committees unacceptable. It is entrusted to the university professors or vice chancellors or retired district level judges. It should be a professional scholars. And at the outset, viewed from any angle, there cannot be any compromise on the fundamental tenets of state policy. Once again, at the cost of repetition, right against self-incrimination is the basis, it's a basic structure. So also no reverse burden is on the prosecution. At any stretch of imagination, no question of confession, testify against himself. These are all the basic concepts in which there is no compromise. We know this government, how it enacted CAA, how it repelled Article 370, 35A. They have majority both in Lok Sabha and Rajya Sabha. And they are in a hurry to make entire criminal law as draconian, stringent, illegal, anti-people, anti-constitutional, anti-internationalism. So the government is making all the attempts to make law which benefits corporate, militaristic, fascist society. I call this committee is pro that fundamental tenets. So I appeal the lawyers from Ernakulam elsewhere in Kerala, please join with other lawyers in Tamil Nadu. They protested almost all cities in front of almost all courts from nook and corner. When Justice Malimat Committee was constituted and it submitted its report, a huge convention was organized at Trichy, Tamil Nadu, wherein more than 4,000 advocates were mobilized. A strong signal was sent to the central government, therefore it was kept in abeyance. Now need of the hour, not just demanding to reconstitute the committee, no. Committee should be abolished. And there must be a united struggle by the advocates. And it's not just affecting the advocates as a check and balance. Courts, that every section of the society, it affects every section of the society. It is very dangerous, it is very serious. Let us join hands together as an advocate fraternity in the interest of society. Let us defeat this diabolical intention of the Home Minister and the Prime Minister. Both are against to the internationally cherished civilized criminal justice system. Thank you, sir. Thank you. I concluded.
Balan sir, thank you very much. Balan sir, thank you very much.
Yes, sir. Thank you.
I now invite P Pramod. Thank you, sir. Thank you, sir. I now invite Advocate P Pramod, State Secretary of All India Law Union, to address this webinar.
Can you hear?
Yes.
Audible?
Yes.
Yes. Okay.
Yeah.
Yes. The moderator of this conference, my friend Dinesh Murikan, advocate, then chief organizers of this webinar, Shri K.K. Nasser, the district secretary of All India Lawyers in Ernakulam Committee, and president Shri P Ramesh, advocate, and all other participants. We had a very good session, very good lecture by one of our senior friend from Karnadaka, Advocate Balan. We are very much thankful to you to present such a wonderful speech, giving some in-depth to the proposed criminal law reforms by the central government. Now, the criminal law reforms, as we know, advocates know, it started some 160 years as in the statute book. IPC in the year 1860, then Evidence Act 1872, then Procedure Code still having a history of more than 100 years. ഇങ്ങനെ ഒരു 160 വർഷം പഴക്കമുള്ള നമ്മുടെ ഈ ക്രിമിനൽ നിയമങ്ങളെയാണ് ഒറ്റയടിക്ക് ഇത് മാറ്റാൻ വേണ്ടി പോകുന്നത്. As our speaker pointed it out, in August 2019, our Home Minister publicly announced that this colonial law relating to the criminal administration system, judicial system, is to undergo thorough reforms. And later, we are also watchful that what will be the further action by the central government. But accepting some statements issued by the Home Minister, in the meanwhile, till January, there were no comments, there were no developments for that to the knowledge of the public or even to the lawyers' fraternity. But in January, all on a sudden, he declared a committee will be constituted. Further, a letter to all bar associations through the Bar Council were also sent under the guise that legal fraternity is well informed and also consulted before going into an amendment. And in that letter, we all noticed that the scope of the committee is not announced, the scope of reference not announced, what are all the proposed amendments which was not announced, in what sort of amendments that will be brought in to which are all the categories wherein the amendments are going to be affected is also not noted. So the consultation appeared to be a very bald one, without having any depth or without having any purpose. But for the sake of namesake, it could be said that the legal fraternity is considered much in advance, even before the committee is constituted. Later in May 2020, a committee, as elaborately stated here before, that a 5-member committee is appointed. 3 of them belong from the law universities. One is a lawyer, and the other is a retired district judge. And no representation from South India, no representation from Northeast, no representation from Western side of the India, and only some members, a few members, handful members from North India alone was deputed. We all know that the process of law reforms is a tedious task, which should be undertaken by law department, union law department, and that does the practice which are following in India for the last 70 years, ever since in the inception of our republic. The law ministry will constitute committees or even consultation with various expert groups, and they will make an opinion, and further they will come with a draft, and it will be presented before the parliament, and thereafter alone it will be going to be implemented. And this process, from the past experience, we know that at least 3-year time framework is necessary to arrive at a new procedure or reform into the existing statutes. That happens to be the tedious procedure. But our Home Minister says that this 160-year-old procedure, criminal law reform, criminal jurisprudence, will be thoroughly restructured within just 6 months. That is a mandate given to the committee. And the committee further, very recently, has issued some questionnaires also. As respected friend, Advocate Balan here pointed out, the legal fraternity or even the civil society was very much apprehensive about some special criminal statutes introduced later on, which will be an exception, which will be a departure from the existing law, that is IPC, to say that the existing criminal procedures have been given a go by. There the burden shifts. Custody is a right. Bail is not a rule. We know that it goes to the basket of laws, draconian laws. But none of these laws, statute books, is sought to be amended or is even thought of amending these draconian laws. But instead, several other laws or several other principles of law in the criminal law is sought to be amended. The questionnaire goes in depth also. And even there is a provision that before the trial, even at the stage of investigation itself, a prosecutor's appointment is necessary or not, is one of the question. So it goes without saying that what is in their mind is only charging of a crime, then investigation with the vigil, with the monitoring of a prosecutor, then prosecution ultimately presenting the case before the judge, and 100% conviction in all the cases. So the script of the police will ultimately be converted as a judgment, is the scheme and plan according to the draft which they have in mind. The draft did not come, but the questionnaire they have in mind visualize that only when the crime is registered, the culprit, the person accused, person in the position of accused, should bear in mind that he will ultimately end up in conviction and will go to jail. So these are all the major departure which is coming to the which is going to be introduced in this. And even extensive references were held with regard to Justice Malimat Committee report also. That also has been a departure from the normal procedure of law reforms undertaken by the Law Ministry, and a separate commission is appointed. And when a retired justice at the stature of Justice Malimat has been appointed, even the very appointment was not questioned as in this case, because here is only academicians, a committee, the very constitution of the committee is in question. But that was not the case with the Malimat committee. When the recommendations come out, when certainly the lawyer community was agitated that this cannot be implemented. And as rightly pointed out here, it was only the change in government in 2004 alone prompted not to implement such a report. Because if that report is implemented, then certainly our penal code and other proceedings will follow the path of special enactments like UAPA or even NSA route, because there is no scope for any trial and there is no scope for any probity as to the commission of offense of the person who was accused. So that will be that they want. And in the Malimat committee report also, the very first sentence starts with the reference that thanks is the extending thanks to L.K. Advani, who was the then Deputy Prime Minister as well as Home Minister. So all these actions, either in the first India rule or at present, is being prompted through the Home Ministry. So that happens to be a sustained agenda, focused agenda by the Home Ministry, by the ruling party, to introduce drastic changes in the existing criminal law by saying that what we inherited is only a colonial one. Certainly, colonial laws which were inherited by us or imposed upon by us, even prior to independence, which are continuing, etc., etc., will it have its own demerits? Definitely, that have to be cured. But that doesn't mean the very tree to be cut down or uprooted. That should not be the way or approach when we are dealing with a colonial law. Enough safeguards have been plugged in the criminal law, which was introduced as a colonial rule. And certainly, after independence, our Supreme Courts have interfered in many of the aspects. Because whenever the courts tends to change the burden, shift the burden to the accused, then again the apex court as well as the high courts reminded that no. The accused, it is not the burden of the accused, it is for the prosecution to establish things. And as rightly said, the actus rea or mens rea part also being agitated in the courts, in the constitutional courts, and there also the burden of actus rea or mens rea in order to arrive at the conclusion that this person has done something offensive, something some criminal offense is also attributable not according to the police theory but according to the evidence which was tendered into the court. So these are all the perceptions which is available in this is existing in the criminal law as of now is undergoing severe change. And I see the recent legislations is in the tune of or is going in the way of a huge corporate salon, not to the common man. As we know, the bankruptcy law has gone tremendous change in 2016. Then NI Act, of course, commercial transactions are now being decriminalized. Then goes to the labor law liberalization, which has happened under the guise of this pandemic control. Everywhere, all the labor law rights have been taken away. Then, with regard to the tax havens, which has been declared for corporate salon, when the subsidies portions are cut day by day, the fuel price is going up, but certainly all the benefits will going only to the corporates by announcing them some tax concessions. Then the new EIA, Environment Impact Assessment Regulation 2020, which also gone in the way of business groups. Then this land classification amendment throughout the country that also going in the favor of a businessman. They can indiscriminately convert agricultural lands into industrial land, etc., etc. All are being commercialized or going in the way of major industrial groups. So slowly, we were moving to this type of corporatism. Now it is very rampant for the last 5 years, and the slow pace of that has been accelerated with full pace, and now we are marching towards that. The ecologically fragile thing was nature before environment, before this dispensation came. But now the fragile class, or even the much protected class, happens to be the biggest corporates in this country. And there is a glimpse, or there is a ray of evidence also there in the reference, because they wanted to change the criminal breach of trust angle also, because all sorts of breach of contracts, when involves breach of trust, when involve other related offenses, see, these are all going to be decriminalized. That also is another indication that the corporates will have their own role in the country. So these amendments are not going to happen to the benefit of the public, to the common man, or even to the downtrodden, but it is aimed at the target is to maintain peace, maintain a good climate for the investors, and even the business house people are being satisfied with all sorts of amenities at the cost of common man. Then the committee, the committee doesn't have any experience, doesn't have any experience at the bar being hired, and there should be a proper mechanism for this, etc., are there that has already been pointed out here. But a committee should have been gone to the extent of saying or preparing, molding a questionnaire that we have a lot of special enactments in the criminal law, like NDPS or even UAP, etc., etc. A lot of special enactments. There, the present procedure, the existing procedure as per the IPC or even Evidence Act has been given a go by, and even CRPC procedures are being given a go by, and a special right is being given for the prosecution to take the accused into the court and get the man punished without having proper safeguards or defense safeguards, as in the case of other criminal cases. So all these special enactments have been carved out as an exception to the present system. Whether this system is system require any relook, any reform, but unfortunately these aspects are not there. We could have arrived at a comprehensive criminal code to say that all these offences, including those attributable to special enactments, would have been at par with other offences, because maybe the punishment part may be much higher in the special enactments, but the trial procedure should have been at par with other offences, and there could be a single code of criminal trial could have been evolved, but not at the cost of existing criminal practice, criminal jurisprudence, but the new enactments, which has given a departure, which has given a go by to the existing procedure, should have been brought back to the system of the existing system, and sufficient safeguards for proving the innocence for an accused should have been there, plugged in the system, and that could have been a progressive or promising reform which is acceptable for the lawyer community. But that is not unfortunately happening, or that is not even unfortunately thought of. Why? Because these amendments are not at the behest of the people, but it is prompted at the behest of the business class, or even the financial interest or economic interest looms large for these reforms, is the experience we have throughout the past several of the past reforms, which I already stated, and that will be the same thing repeated in this case also. And with regard to the constitution of the committee, its methodology, its analysis, or even its findings, there are so many criticisms, so many groups have come forward criticizing the even the constitution of the committee itself, their authority to form a comprehensive system in place of the existing system within the span of 6 months, and without having proper consultation with other groups. They say that only the lawyers are consulted. It is not affecting the lawyers' provision. It is not affecting the courts. It is not mere affecting the judicial dispensation system. It is affecting the common man, public at large. It includes all classes of people within the society, whether it is marginalized community or even the scheduled community or in the women community. Everywhere, everybody is affected, because this law will be universally applicable to all citizens of India. This 36 crores of people in India. So the consultation should have been a wider one. That is the main cardinal objection which was raised. Almost 600 groups of civil society organizations have already raised a protest before the Home Ministry and even before the committee, by saying that the consultation is not enough, or it is not at all worthwhile. It should have been expanded more. 69 lawyers from Supreme Court as well as various high courts have also pointed it out that there are in India several other lawyers are also there. They were also not in the committee, and even the lack of experience of the members is questioned by these lawyers. Even many eminent judges, retired judges, have also pointed it out that this should not be the way at which a criminal law reforms should have been done. As our senior friend Sri Advocate Balan, S. Balan pointed it out. We are suspecting that they have a pre-scripted draft available with them, and it will be come out to the stage soon. That may be the modus operandi by posting these sort of persons, these sort of panel for this tedious task. If it is a judge with credential, with the stature, he may not accept that to copy down a draft which is brought extraneously from other corners, and it will be presented as their report. So in order to avoid all these conflicts, they just wanted to have a committee with one person from National University Delhi, Law University Delhi, registrar from National University Delhi, then another professor from Dharmasala National University, and one district judge that it will have to retire, etc. So they want keep up the expectation or the aspiration of the common man, or even the legal fraternity, or even the experts, or even other social groups. But they will be at the they will be aiding with the they will be at the aid of or at the help of the Union Home Ministry, which already spoken about reforming the present law. Then we may not forget that Law Commission in India have submitted several reports on this very same subject. I think 241, 239, or 243, etc. reports number. All these reports pertain to criminal law reforms. And even prior to that, there are several other reports. But these reports are not at all being reckoned. Or the committee should have been asked, the public, or even legal fraternity, or even the experts, to say that you please go through the legal reforms committee, law reforms committee recommendations. These are all the recommendations. Whether we should opt for this or we require any modification to this. This also not being suggested. So what is the interest? Interest is a preset agenda and a preset script, which will be introduced soon. Maybe the reference. And even to the queries, there is a rider. Your objection to each query should not exceed 200 words. There is a limitation also. If it is beyond 200 words, it won't be accepted also. So this type of deliberation is not at all helpful in order to make the system more transparent, more vibrant, and more progressive. And we should go to a new era of criminal jurisprudence. Okay, forgetting about the colonial backlashes, we should move forward further. But the example, there is no pre-existing example so far as India is concerned, and we should set an example in India afresh. That is a necessity, because before British India, before British ruled India, the princely states doesn't have any common jurisprudence or criminal law. There is no code of set of code of legal principles or court even, because this India, the British India without Pakistan, the present India was having 555 princely states joined together is the present India. So there were 555 or 556 legal system were existing in India. That is the that happens to be the situation. So which system we will inherit? Which system we will want to go? There were no democracy. There were no democracy is being introduced only by the Britishers here. And from 1950, we are following a system wherein we partly took the system of England as well as some of the principles in American democracy, which are also further, some having 200 years history. So we hired several principles of existing democracy, not from the princely states of former British India. We inherited the system, but of course it happens to be a democratic one. So when we wanted to say that no colonialism, okay, well and good, that's nice. But we should not go to a system wherein some 500 or 1,000 years ago, or even to the extent of saying that we are marching forward to Ramarajya, which happened some 500 or 5,000 or 6,000 years back, presumably, or even it is only an epic in the storybook or even the Ramayana. So that is a imaginary version. So we cannot march towards a system which happened in Treta Yuga, but we should move forward to the modern world by saying that India is setting an example by taking all the system, the benefits of all the system. Then we are creating another one. So now we will say that all indigenization, foreigners should go, and we are moving towards Bharata or like that. That will be the concept now available with the several persons. So what is this concept? Is it amenable to modern democracy? No. It has been a system in princely states or even other feudal systems, but not in democracy. So whenever a change is there, it should have correlation with our existing constitution, correlation with the rights guaranteed under Article 14 and 19 of our constitution, and also it should have a correlation to whatever the precedents which were declared, sound precedents which were declared from 1950 to till date by apex court or even the high courts. That is a practicing. That is the present day. All these contributions have made finally the present day modern jurisprudence were richer. So all these aspects has been taken. Then alone we can arrive at a new system. But this will not serve the purpose. That is the basic observation which existing in throughout the legal fraternity, and I assert that lawyers union also have the very same firm opinion that the present reforms, sought after reforms, will not serve the purpose, and even the constitution of the committee, composition of the committee, as well as its reference, or even the questionnaire has been agitated, challenged, and several representations have already been sent to the Home Ministry as well as the commission by the Lawyers Union National Committee, and we are holding deliberations or consultation on the agenda on this subject, and we will be submitting a very progressive one or very alternate suggestion to all these things, and even we will go to the extent of saying that all the draconian laws which is in the statute book as special statutes should also be repealed or should be amalgamated with the comprehensive code of criminal trial, and all the accused, either that happens to be in a special statute book or in the IPC, should follow the very same procedure, because accused in one case IPC or an accused in another case, say a special statute, should have at the same footing or at par in the so far as the rights affecting his custody, his trial, or even his investigation, etc., are concerned. So there cannot be any discrimination, and all these discriminations should end, and we should move forward to several UN human rights declarations also to achieve such a thing. Then alone, our democracy will be fruitful, and we should not, at any rate, be privy to this type of draconian or even adverse reforms. I assure that Lawyers Union also will be in the forefront to fight against these moves in the coming days. We are organizing, our district committees will be organizing such type of webinars during this period. If I'm for a moment think that if this type of pandemic restrictions are not there, we should have definitely been to the streets. And the central government is also knowing that nobody will be into the streets just because these COVID protocols are there. So they introduce hastily all these things at this stage. So this is operating in a deceitful way. This should not be the way at which a far-fetching consequences should be presented to the public, and it should be taken on a later stage. Now focus on the pandemic situation. Now focus on the health reasons, not in other areas. But under the guise of this, Several things have already happened, but of course, as like you can have a reasoning for taking away labor laws at the cost of COVID situation, but you cannot have a reasoning logic for introducing a criminal law reforms which have drastic, which will introduce drastic changes to the present system under the guise of this COVID or under citing the reason of this COVID exigency. There is no exigency is there. So please, the central government, I urge that for my organization, I urge that the central government should assist from the way the present reforms, and certainly the job should be assigned to the law commission. They will have proper deliberation, and ultimately these are all should be routed to the parliament, which is the paramount legislative body wherein the people's real interest will be reflected. Of course, it will be guided by the majority. There is no question, but still, a dissent will be there. There will be a discussion, and even for interpreting the law in future, disputable or disputed clauses is agitated before the courts. Certainly, the legislative intention could be a debatable point in the court. And when a parliament debate is there, certainly that would have been the better way to arrive at such a situation, such a amendment, and not by a secret committee. There is not by a private committee which doesn't have any statutory backing. So please assist. I urge that the central government should assist from the present amendment, and as pointed out here earlier, either by the inaugural address by Comrade Rajeev or even by senior friend Advocate Balan, we will not agree with, we should not agree with the present committee who will be going to submit the report. So by this, I also wish to conclude. Will once again, because during this webinars, we have a time limit definitely. This should have been done as a workshop. We should close by close, the questionnaire already issued by the committee should have been discussed, but time doesn't permit for us, or the present situation doesn't permit us. But of course, this should be done segregatedly, separately, and different committees of lawyers union at different stages, different phases should discuss all these things in reference to what is their proposal and what is the existing precedents, or what is existing statute or the system. We should make a comparison. We should arrive at conclusions, at proper conclusions, that whether this will affect adversely or not, and a discussion, very serious discussion on its merits, on it the academic side should be carried out. And I also use this opportunity requesting our Karnataka counterpart or Karnataka friend Advocate Balan sir or his colleagues to have to come to Kerala, or even through webinars to assist us or even to guide us. And we will also reciprocate like this whenever there is a conference or webinar or discussion happens in future. Certainly we should work together, especially the southern states. We can move together, because no consultation, no committee member at least is there to echo the voice of southern states, which have a different cultural background when compared to the northern states. Thank you, sir. Thank you all. Especially, I extend my wholehearted appreciation to the to Advocate Balan, sir, on behalf of Lawyers Union State Committee. Thank you, sir. I am stopping with this. Thank
you. In this webinar, more than 100 participants had participated. It was glad to note that there are advocates practicing from Delhi also participating, from Karnataka also had participated in this webinar. Now I think that this first attempt of the Ernakulam District Committee is a success. We assure you that we'll be continuing our webinars, and senior advocates Advocate Raju Ramachandran, Supreme Court, also had agreed to attend in a webinar committed by us. Now I request Advocate KK Nasser to render vote of thanks.
Unmute, Nasser. Unmute, Nasser. Unmute you. Yes.
Yes, good evening all. It is my privilege to propose vote of thanks to all. First of all, I will propose vote of thanks to Mr. P Rajeev, who is our leader and he is the chief editor of Deshabhimani, who has given a speech, inaugurated this session. Then thereafter, Advocate S. Balan. In fact, we have planned this webinar only 1 week back. Immediately we contacted Mr. S. Balan sir, and he agreed to participate in this seminar. And he has given a very good lecture in this particular subject. On behalf of All India Lawyers Union, I thank Mr. Balan sir on behalf of the company. Then I propose vote of thanks to our leader, P Pramod sir, who has also given a very good speech in this subject. And I propose vote of thanks to our leader, Ledati Rangappan, then our TP Ramesh, then CM Nasser, and all other participants here. Then I also, my special thanks to Shami, Advocate Shami from Trivandrum, who has helped to conduct this webinar in such a beautiful manner. And my special thanks to all participants in this particular webinar in a short period. Thank you all.